What do you do if you get into a dispute with one of your clients? You may think about taking them to court, but that's expensive. Fortunately, there are other things that you can do before it gets to that. I'm Kalila Reynolds, and it's time now for another episode of Money Moves JA, brought to you by Exim Bank's Business Advisory Service, giving you the tools to grow your business. Attorney at law and dispute management practitioner Dr. Chris Malcom is back with us today, and make sure you watch this video to the end because I have a giveaway. Welcome back, Dr. Malcom.
Thanks, Kalila. Thanks for having me again.
Well, you sure gave us a lot to reflect on last time and to implement in talking about our contracts. What are the things that we ought to be included in our contracts? What is a contract? And of course, naturally, not all the time that you have a contract, whether verbal or written, do things go according to plan. Disputes naturally arise. What do we do then?
Therein lies the million-dollar question. What do you do, when, and how? And I said on the last occasion we spoke that a contract was there to regulate. It's a regulatory tool, right? Or dispute, but it is also something else. A contract is also a dispute management tool, if you think about it. Now, what happens is that we very often, in a very loose way, speak about dispute resolution. We speak about resolution through the litigation process, for example, which is through the court. And we speak sometimes about alternative dispute resolution, which countenances things like arbitration, mediation, conciliation, good offices, neutral evaluation, and so on. We speak about those glibly. But the fact is, and I like to center it a little differently, I like to center it on the basis that the entire process of the practice of law in a very general way, and all we do surrounding legal affairs is simply as lawyers and as people in the field operating as dispute management practitioners. Why do I say that? If we go back to what I said about contract, which is that it regulates relationships between the parties. What you have happening is that the core problem that arises when things don't go as they should is that somebody has to determine how to resolve problems that arise. So what you want to do from the outset is to establish a management process, which firstly doesn't think about resolution, but thinks about dispute avoidance and prevention. That's your starting point. And then you want to ensure that you put systems in place where if things do not go correctly or the way you want it, you can then have a seamless system for resolution. And ultimately at the back end, you want to know that even after resolving, you're able to collect upon what it is that has been resolved in your favor. So I then like to think of the whole
concept. That's the very important part, collecting.
That's perhaps the most important part, actually. But I like then to think of it in this way. So we have a tool shed with several tools in it that we need to think of. And one of the things that people don't often think about when we think of dispute resolution, or as I prefer to think about it as dispute management, is a simple act of negotiation. Negotiation is a front-end tool for dispute resolution in that you are able to, in contractual and business relationships, when you're entering your contract, you're able to sit down and negotiate the terms of your contract in a way which makes it difficult for disputes to arise, and also if they arise, to make it easy for them to be managed. So what you have at the front end is something where you can determine that in the event, for example, of a dispute arising between the parties, they will resort to amicable discussion among themselves. Or they will call upon the parish priest to perform good offices. Or they will use some of these very low-end, low-cost mechanisms that can help them to themselves resolve their disputes. But with the best of intentions, sometimes these don't work, and you need the intervention of a third party. And you then get to persons like a mediator who you may be able to bring in to assist you in resolving your dispute. Now, the beauty about a mediator, when they come in, is that the mediator does not actually make a decision at all about anything. The mediator is there to assist the parties to themselves make a decision. And if that fails, you then go to the more adjudicative methods of things like arbitration, where you then engage a third party, not in the court system now, who is able to hear the disputes as though you were in a court and is able to make a decision which is binding as though it were a judgment of the court. And
So
you
that's the main difference between a mediator and an arbitrator.
an arbitrator. The mediator has no capacity to make a decision, while the arbitrator is empowered as a matter of law and contract between the parties to make a binding decision which has the same effect as though it were a judgment of the court. And then, of course, you ultimately have the court, which regulates all dispute resolution mechanisms, including arbitration. Why? Because arbitration, mediation, and all of these other things are themselves contractual. You have a constitutional right of access to the court, meaning I don't have to tell you that I'm going to sue you to be able to sue you. But you have only a contractual right of access to arbitration, mediation, and these other methods called ADR generally. Because if you and I don't agree and I go to involve an arbitrator, you simply say, where are you going? I didn't agree to that. The only place you can take me without inviting my involvement is to the court. But you cannot go elsewhere. So the court has this overarching constitutional role that it performs. And that role includes its capacity to regulate relationships in ADR, because those are contractual matters and contracts are subject to ultimate determination by the court.
So what is ADR?
ADR is usually considered to be alternative dispute resolution. I much prefer to consider it in a more progressive way as appropriate dispute resolution. Why? Because it is not always alternative to anything. It can sometimes be and should always be complementary to the court and other systems. Because what you're trying to do really is to get the parties to choose what is best for them in the circumstances to get the best resolution possible in the lowest cost manner possible. That's what you want to do. And again, we get back to the question of risk management, because risk management also includes management of costs, right? So you want to find a way to ensure that even when people are resolving their disputes, they do not overextend themselves in costs if costs can be avoided.
Absolutely. So to recap, your hierarchy of dispute resolution, try to work it out amongst yourselves.
Yes.
And then you can go to maybe a pastor, priest, somebody in the community, maybe even a justice of the peace.
Yes.
Mediation, then arbitration if that doesn't work, and then finally the courts would be your last resort.
There is, yeah, but there's one thing I need to add there. In many instances, if you go to arbitration, the contract precludes you from going to court. Because because arbitration and the court process effectively have the same sort of finality in decision making.
Right.
The usual position is that if a decision is made in arbitration, just to use a legal expression here, you may have gone to court and heard them say a matter is res judicata. It has already been determined, so another court cannot look into it, right? If you and I have an issue, getting back to the pen we spoke about last time, that I owe you money for the pen and you sue me, and the court determines that I don't actually owe you, and if you were to subsequently take the matter before another judge, my immediate defense is that there's issue estoppel, there's a res judicata effect of the judgment that you have already had before a court, and that you cannot subsequently take a matter to be determined that has already been determined by another court, yes? Now with arbitration, an arbitration award has exactly the same res judicata effect. So if a matter were determined in the arbitration, and you subsequently took the same matter before a court to be determined, I would also raise res judicata and say, but a competent authority, being an arbitrator properly authorized by law, has already made a decision, so you cannot raise it again. You would be stopped in pretty much the same way.
I
So
see
the
where
two,
you're coming from.
that's where it is. But the fact, however, is you can raise issues in the arbitration, such as whether or not an arbitrator was biased, whether or not he or she acted properly and so on. And you can then go to court to make challenges in relation to the fact that the decision is not a proper decision because there were some difficulties along the way in terms of how the arbitrator may have conducted him or herself and so on. So those are instances where you'd be able to go for court support. And in relation to, for example, you may need an injunction. The arbitrator has no capacity to grant an injunction ordinarily. So you can go to the court for supporting orders to support the due process of an arbitration as well.
I see. I feel like I was in class taking my notes. Thanks again so much, Dr. Malcolm. Much appreciated.
You're welcome, and I trust we can have these and further conversations whenever you're available. I'm able to assist to the extent I can.
Certainly. Thanks again. Here's a recap of Dr. Malcolm's key points on dispute management. A contract is a great dispute management tool. Negotiate terms in a way that makes disputes difficult to arise and easy to resolve when they do. If you're unable to resolve a dispute by yourselves, try using a mediator or an arbitrator. Time now for our giveaway question. What's the main difference between a mediator and an arbitrator? Answer over on Exim Bank's Instagram page at EximBankJA, and you could win a lovely prize. That's it for this episode of Money Moves JA, brought to you by Exim Bank's Business Advisory Service, giving you the tools to grow your business. Check out their website, eximbankja.com. I'm Kalila Reynolds. Until next time.